A Western Sydney apartment developer receives tender returns $2 million above your concept stage cost plan. The financier is reconsidering the construction facility, and the developer's solicitor alleges that the feasibility numbers were misleading. The report says estimate only, subject to final design, but that disclaimer is not the whole answer. 5 key points follow. First, an estimate-only disclaimer can help define the limits of preliminary cost advice. It does not protect a cost plan that lacked a reasonable basis when issued. The real question is whether the assumptions, exclusions, contingencies, and design limits were clearly communicated. Second, a tender blowout dispute is not simply about whether the budget was wrong. The critical issue is often causation. Later design changes, specification upgrades, authority requirements, or client instructions may explain why the tender price moved. Third, proportionate liability may reduce a quantity surveyor's exposure. If architects, project managers, principals representatives, or the developer contributed to the loss, the claim should not remain at the level of the budget was wrong. Responsibility must be analysed by reference to actual contribution. Fourth, the Design and Building Practitioners Act 2020 may create additional risk. That risk arises where cost advice moves beyond pricing into project management, design coordination, or value engineering. If that advice affects building outcomes, the dispute may extend beyond a cost overrun claim. Fifth, a defensible cost plan depends on contemporaneous records. Those records include assumptions, exclusions, drawing registers, RFIs, benchmark rates, escalation treatment, and client instructions. A generic disclaimer is weakest when the file does not show what was priced and what was excluded. If your firm has received a demand over a preliminary estimate, tender overrun, or value engineering recommendation, contact Merlo Law for early dispute strategy today.